is that private property owners should have the right to permit only gun owners to be on his property, only non-gun owners, neither of them, or both of them. And we should be able to permit that for good reason, for bad reason, or for no reason whatsoever. So property rights trump. When it's private.
On the topic of sensible regulation, it seems like there's a black and white view on a lot of either gun rights or pro-gun control. But I think there's a gray area, and that comes down to different regulatory issues, and you talked briefly in your speech on sensible regulation and other things. The issue I want to bring to light is, for example, the restriction of certain individuals to own firearms. That currently is done on state levels as well for felons. Now, the defining line here, with the exception of domestic violence, the defining line is misdemeanor to felony. And you spoke about the Second Amendment trumps state regulations on certain things, like, for example, the state of Utah, in its constitution, has verbiage on gun rights to the point of you have the right, but the state can regulate it and issue laws that can constrict that. And also, you spoke on 3 premises in which the government should have to consider, per se, to be able to create those regulations and or restrictions. How do you feel about that?
Well, this is being litigated, again, as we speak, with dividing line between misdemeanors and felons. I think it's an arbitrary dividing line that really doesn't make a whole lot of sense. The dividing line ought to be based upon the nature of the crime that was committed, and whether or not the gun was used in the crime, and whether or not there were violence involved in the crime. So the ability to, and there are some felonies, of course, that don't involve any violence whatsoever, and there are some misdemeanors that do involve violence. So that seems to me to be a more rational guideline, and the courts are going to have to thresh this out. But there are cases that are being litigated to address the prohibition of gun rights to felons who have never committed a violent crime. It does seem to me to be outrageous, and I would hope the courts will go along.
Now, would, like you explained, that Second Amendment trump a state constitutional law or amendment that would say, for like Utah, well, we get to decide?
The nice thing about this issue, it's going to be whichever gives it the best view. So if the federal constitution is interpreted by the federal courts to protect a felon who hasn't committed a violent crime and giving him gun rights, maybe they could do so after a certain period of time. Whatever the rule is, if the U.S. Constitution is determined by the federal courts, that would trump any state constitution. On the other hand, if the state constitution is determined by the state courts for providing that right, that would trump the U.S. Constitution. Bear in mind, the U.S. Constitution says you have the right. It doesn't prohibit you from having the right. There's nothing in the U.S. Constitution that says a felon can't have a gun. But there is something that says you have the right to bear arms. So it's a permission in the U.S. Constitution, not a prohibition. Whichever source of authority is the best deal on that issue.
What do you deem a likelihood of what you see being overturned in the court?
Not very high. The courts are very reluctant to overturn past precedent, particularly in an issue that's, this issue is probably as emotional for people, any issue other than abortion. And it has political sensitivity, as I'm sure you all know. And the NRA, however ill I may have spoken of them during the talk, they are a formidable gun rights organization. They do great work, and they have enormous political clout. So I don't think that the Supreme Court wants to wade into this political thicket again if they can help it. And I do think the Supreme Court wants stability and predictability and certainty in the law. And any time the law starts changing over short intervals, that diminishes respect for the law. And the court has to be sensitive.
There's a number of issues that a lot of people familiar with gun rights are aware of. California's got may issue status, where a law enforcement officer says, we don't believe you have significant right to get a concealed carry permit. There are other issues like like the sporting purposes language that a lot of laws use. What do you see is going to be the biggest target to attack down to help increase the meaning of the Second Amendment as it is now?
Yeah, well, and look, if concealed carry prohibitions are deemed to be constitutional, then certainly may issue constitutional. So if you can issue with discretion, that's more liberal in terms of protecting your rights than if you can't issue, if you're not going to issue any permits at all. And I don't know how the court's going to.
Well, it's not so much about how the courts are going to. Which one do you see is going to be the best one to attack on the right? And as far as the may issue status, you are right. You know, it is. They are granting some permits, but there are notorious counties in California, New York, things like that won't issue to anyone unless you're connected or rich.
The best approach, in my view, is the same approach we used in health. That is the incremental approach. You attack the worst situation first. You proceed in increments. Get a good decision, try to build on it. The worst situation is in Illinois, where there's an outright prohibition on carry. And so that's where you want to attack. Or in some municipality that has an outright prohibition. You don't go after the main issue, you can go after an outright prohibition. The worse the situation, the better the likelihood of going. And then you try to build it. That's the fact.
How much weight do the little logical proofs that we use, like a guns cause crime and pencils misspell and cars speed, how do those hold up in the high political circles if they've been used at all? And if they haven't, why not?
You're talking about the extent to which the court gives weight to the empirical data, the statistical evidence? Is that what you're saying?
Well, like a simple fact, like, you know, people will, you know, they'll sue firearms manufacturers like, oh, your thing, you know, your products kill people. But no one sues Ford and Jack Daniels for someone drunk driving and not going after the person that was driving it. Why is it seems that that's okay for firearms and not other things, when logically it's still an inanimate object, that the end use of it is up to the user?
Well, this probably doesn't come under the rubric of the Second Amendment. This is tort law, and whether or not a manufacturer can be sued for unreasonably dangerous products that he sells to the public. And the rule that I think ought to prevail is that if there's full disclosure, if there's a warning, then the consumer is on notice. And so any injury that occurs to the consumer himself is because the consumer voluntarily assumed the risk by buying the so-called unreasonably dangerous product. That does not, however, answer the question of whether that injury to the innocent bystander. There's a more complicated question, but I think you're right. It's the same kind of question that occurs with respect to an automobile. And what this generally boils down to in the courts is a utilitarian calculus. That is, what are the costs involved of imposing these kinds of restrictions versus the benefits involved when the restrictions are imposed. How much is public safety improved on the one hand, how much inconvenience and excess cost. And that's what the courts will weigh in making these kinds of decisions.
Thank you.
Not a Second Amendment. Yes.
Since the Heller v. DC case was decided, and in reality, have we seen any changes in the laws in DC or laws in general because of that case? Or obviously, people that made those laws would be somewhat reluctant to change.
Yeah, well, all three of the laws that we challenged in D.C. Have been repealed. So there's no longer a ban on handguns. There's no longer a ban on carrying handguns from room to room. And you can now keep rifles and shotguns loaded. They don't have to be trigger locked and disassembled. There is a provision that says that kids can have access to guns. There has to be some kind of safety mechanism, that could be a storage mechanism. Trigger lock. But what DC hasn't done, and once again, still being litigated. Yeah, this stuff happens slowly. It takes a long time. It took us filing the case in 2003. We can get a decision in 2008. That's 5 years of litigation for the one case. So what's being litigated now are several things. One is DC is such a burdensome procedure for becoming a retailer. that there are no gun retailers in DC. So what good is the right to have, if you can get armed, if you can't buy a gun? There's nobody in DC that will sell you a gun. Nobody, zero. I don't mean one or two, zero. There was one guy, and he had nothing but a post office box.